December is False Sex Offense Complaint Awareness Month. A sex offense complaint is where someone claims they're a victim of a rape or, in Florida, what we call a sexual battery or a lewd or lascivious offense or some other type of sex crime when in fact it didn't happen. Perhaps somebody feels guilty. Perhaps they've been slut-shamed. There are a number of different reasons why people can make a false sex offense claim, money being one of them quite often in high-profile cases. A lot of people are saying, as in the case with domestics, oh, these crimes are underreported. Here's the reality. We're living in rape culture. When someone is accused of a sex offense and prospective jurors walk into the courtroom and they hear the charge, they're not sitting there, and I tell you this from practical experience, having been in the courtroom, they're not sitting there looking at me and looking at my client and going, gosh, I wonder why the client was falsely accused. No, they're sitting there thinking, I wonder what he did. This is a real problem when people can make a complaint on virtually no evidence whatsoever except testimony. And in cases of consensual sex, DNA is gathered, but it really doesn't mean anything because of the issue of consent. A final point you may not be aware of. You've heard of polygraphs. You've heard they're not admissible in court. Here's what you haven't heard about Florida law. Did you know that if someone is found guilty or enters a plea of guilty or no contest to certain sex offenses, they are required by law to be polygraphed every single year? Now, let's go into the common sense corner over here. Before trial, a polygraph is not admissible, but if someone is convicted, they have to take a polygraph every year. What this means is in our rape culture, we have a stacked deck. If you or someone you love is accused of a sex offense, contact Cobb Law Firm. We'll defend your rights as best we possibly can to the highest professional level.